Welcome to our webinar. I'd like to introduce first and foremost Troy Byrd. He's the General Manager of Screening One. He manages the day-to-day aspects of the company. Troy is responsible for the overall integrity, functionality, and management of Screening One. Troy is a graduate of Florida State University, where he has earned a Bachelor of Science degree. He joined the Screening One staff and has been with the organization for over 11 years. Welcome, Troy.
Thank you very much, and thank you to all of our attendees for joining today's webinar. Today, what we'll be going over is learn how to avoid tenant screening and litigation and protect property management company. Today's day and age, unfortunately, litigation is becoming more and more of a pressing or hot topic. So today we're going to talk about where the hot spots are for litigation and how you can mitigate potential risk by looking at your background screening program. So to kick things off, the things that are changing fast in the background screening business, Fair Credit Reporting Act, often referred to as the FCRA. The Fair Credit Reporting Act, I'm sure everyone has heard of at one point in time. A lot of people hear credit and assume it automatically relates to anyone accessing credit reports. But the Fair Credit Reporting Act is actually the foundation of consumer rights law in the United States. The legislation was built to promote the accuracy, fairness, and privacy of consumer information that is contained in the files of consumer reporting agencies or background screening companies. The FCRA is intended to protect consumers from the willful and or negligent inclusion of inaccurate information in their consumer or investigative consumer reports. And the FCRA is enforced by the U.S. Federal Trade Commission, the Consumer Financial Protection Bureau, and private litigants. We'll also be spending a little bit of time on HUD and specifically the guidance that was issued by HUD on April 4th of 2016, which I'm sure a lot of the attendees have referenced or seen. The guidance is for all housing providers regarding the use of criminal background checks and how they could potentially violate fair housing laws. In the guidance, they have a heavy focus on disparate impact discrimination, so we'll talk about that in a little bit. First, we're going to cover the Fair Credit Reporting Act. Currently, under the FCRA, there's 3 key sections that are being heavily litigated. I honestly could spend the entire webinar series going over the amount of litigation going on with the FCRA, but today, to keep it short within a specific time frame, we're going to hit on 3 key major areas. And those areas are procedures that consumer reporting agencies have to follow, specifically Section 607 of the FCRA. Number 2, disclosure and authorization forms, making sure your forms are up to date with the federal and state guidelines. And then also the adverse action process. When you make a decision on a prospective tenant based off of the use of consumer report, under the FCRA, there are certain obligations that you must follow to ensure that you're remaining compliant and giving that consumer a reasonable amount of time to dispute the information found within their report. So we'll touch base on all 3 sections, and maybe we'll sprinkle in a couple of other hot topic items. First, let's talk about reasonable procedures. This is honestly the biggest litigated item right now within the Fair Credit Reporting Act. Specifically, I'm referring to Section 607. Section 607 of the Fair Credit Reporting Act states, whenever a consumer reporting agency prepares a consumer report, it shall follow reasonable procedures to assure maximum possible accuracy of the information concerning the individual about whom the report relates. So what does that basically mean? It means that the use of database or instant criminal background checks is no longer adequate. In the tenant space, a lot of companies refer on or rely on national criminal database searches. They're fast, they're cheap, you get results quickly. This section is becoming very litigated because those national criminal databases inherently contain outdated, inaccurate, or incomplete information. That leaves you vulnerable to liability. Now, to follow reasonable procedures to verify the accuracy of information, basically you must conduct a consumer reporting agency must conduct a county-level search to verify its accuracy. When we are, in regards to background screening, the best, most accurate search a background screening company can conduct is a county criminal search. In our industry, that is considered the source of information, of criminal record information. Whenever an individual gets arrested, charged with a crime, or goes to court, those local records are housed at the county courthouse. Since that is the source of the information, it's going to have the most up-to-date and accurate records on file. The national criminal, why it contains inaccurate or incomplete data, it is simply a database. It relies on several different entities to obtain criminal records. It could be county courts, statewide repositories, local law enforcement, the DOC or Department of Corrections, or the AOC, the Administrative Office, of course, along with several other different resources. So what we have found is the National Criminal Search is it may obtain an original record. Okay, maybe someone went to court for possession of marijuana, was found guilty of that offense. A lot of times with crimes, especially for first-time offenders, you may get charged, plead guilty to an offense, and the court will give you a probationary period. If you successfully complete that probationary period, you can have that charge dismissed. The issue we find is sometimes those national databases may only get the original plea of guilt, and they may not get the updated case information when that charge may get dismissed 6 months later. So that creates liability both for consumer reporting agencies and landlords and property managers, because if you're reporting that database information and it is inaccurate, you could be causing harm to that consumer. That is one of the main areas of litigation that we're seeing right now, is the inaccurate information from the database being held against an individual. Yes, we do have the adverse action process, which we'll go over in a little while, and that the whole adverse action process was meant to be the buffer of giving that opportunity to the consumer to dispute the records that were found against them. But we have seen litigation increase even after an adverse action process was begun, a dispute was filed, and the report was amended. We still see litigation because it still causes harm to that individual. Maybe they didn't get the apartment they desired, and by the time the dispute was completed, that apartment was no longer available. So it causes a lot of concerns, and we're seeing a trend right now within the background screening industry where more and more companies, we're still offering the National Criminal Search, but if there is a possible record, we have to verify it with the source, and that's the county criminal. So in the United States, there's 3,200 jurisdictions. With the county criminal, it is not as fast as a national criminal inherently. There's several different ways that we can conduct a county criminal search. Some courts have public access terminals, which is simply a system that can be accessed either remotely or at the local court. In those jurisdictions, we see fast turnaround times. We can get those back easily within 24, 48 hours. Other courts don't have the technology in place for a public access terminal. And in some of those jurisdictions, we have to actually send a researcher out to that court and request a file directly from that court clerk. So the turnaround time can vary, but in the grand scheme of things, what is an extra 24 to 72 hours compared to a class action lawsuit or a multi-million-dollar lawsuit? It's one of those areas where you really have to weigh the risk and reward of obtaining a search in a quick time. So when it comes to the Section 607, the FTC depends on what reasonable procedures to ensure accuracy are. Certain practices may be indicators that a background screening company isn't following reasonable procedures. For example, if a report lists criminal convictions for people other than the applicant or tenant, for instance, a person with a different middle name or date of birth, that could be a sheer indication that your provider may be relying on one of those databases. So when these databases are conducted, most criminal searches are conducted by name and date of birth. A lot of people do not realize that because criminal records are considered public information. Because they're public information, we can't search by a social, we can't search by an identifier such as that, because if the courts had a social readily available, we'd be dealing with a lot of fraud. So with these national databases, your provider, it's important that their parameters are strict in regards to how they search for criminal records. Under the FCRA, a consumer reporting agency, when we report a criminal record, we must have a minimum of 2 identifiers to link a record to an individual. 2 identifiers are considered full name, so that's first name, middle initial, last name, that's one identifier. A full date of birth, so that's month, day, and year. If we have anyone on the call from the state of Virginia, one of the biggest issues companies such as Screening One and my competitors, what we have come across is the state of Virginia has started redacting the year of birth on all their criminal records. So if we submit a request to Virginia and we get a name and a partial date of birth, in order to meet the FTC or the FCRA's Section 607 of reasonable procedures, we must have 2 full identifiers. So we're seeing longer turnaround times in Virginia simply because the state is making it more difficult to obtain a full second identifier since they're redacting the year of birth. So it's important with your provider that they are using proper procedures and reasonable procedures to verify the consumer's identity, and that's using multiple identifiers. The FCRA also states, or the Federal Trade Commission has stated, that national criminal databases, since they can contain inaccurate information, that does not meet 607's requirement of reasonable procedures. So it's important that, you know, in the FTC, in their 607 opinion, the only way a national database can be utilized and could be argued in a court of law is if there is verifiable evidence that every single resource that reports to the national database is updated every 30 days or less. In all honesty, there's not a national criminal database out there that updates all of its resources within 30 days. So with that being said, the utilization of a national criminal database for your background screening, and that being the sole product, it's hard to win a claim, a 607 claim of the FCRA if that's the only product used. So what you're seeing is more and more companies in this industry validating those records at the county level. If they're not, you should review your program because compliance is key. I'll talk about it in a little bit, but for several years, tenant screening, there weren't a lot of FCRA claims or litigation based around it. But in today's day and age, it's becoming more and more prevalent. We'll get into that in greater detail in a little bit. So the next item is disclosure and authorization forms. Most of you, if you have a background screening process in place today and you have a vendor in place today, recommendation, obtain that form from your vendor. What we have noticed is an uptick on the amount of litigation based off of the wording in those authorization forms that the consumers are signing, which authorize you to run a background check on them. Under the FCRA, it states that applicant must be notified and give written permission from property manager or landlord to obtain the background check. And it's vital to make sure that your forms are up to date. State and federal laws change frequently, so it's important that you review your forms or, stay in contact with your current provider. Review your forms and review them often. You want to make sure that they're as compliant as possible. One other area that's heavily litigated right now, and we talked about state laws right here on bullet number 2. There are a lot of state laws out there that pertain to what a background screening company can provide in the form of a consumer report when it comes to criminal records. A lot of that, so beyond the FCRA, some states have laws that restrict consumer reporting agencies from reporting records beyond a certain date. Most states that have this law, it's usually a 7-year reporting law. For example, in the state of California, consumer reporting agencies and end users, which would be you, cannot hold against an individual records beyond 7 years or non-convictions. A lot of this will tie into the HUD guidance that we'll go over in a little bit, but there are several states out there that have 7-year reporting laws where we cannot report and you cannot hold against that individual any crimes beyond 7 years. There are also some states out there that have specific laws regarding annual income. For example, in the state of Kansas, consumer reporting agencies can't report, and end users, which would be you, cannot hold records against an individual beyond 7 years if their monthly income or annual income is less than $20,000 a year. Other states have like $75,000 rules, like Colorado and Texas, where you can't report records beyond 7 years unless they make over $75,000. The whole purpose of these state laws is to give the consumer a benefit of doubt that if they're based on their wage, they want them to be able to get a job or get an apartment. So that's why these different states have these rules. Kentucky, for example, can't report non-convictions against an individual in Kentucky. So it's important when choosing a consumer reporting agency that they're aware of these laws. Here at Screen One, one of the important things that we do, all of our investigative analysts are highly trained on the Federal Fair Credit Reporting Act and each individual state law. We filter all of our records to ensure that the information that we're reporting to you can be used in your final decision-making process. So we apply federal law and we apply state law based off where that consumer lives to make sure you can make your best decision possible. All right. Next, we're going to talk about the adverse action process. An adverse action is any action by a landlord that is unfavorable to the interests of a rental applicant or tenant. This is Section 615 of the FCRA. The Fair Credit Reporting Act says that an adverse action is any action by a landlord that is unfavorable. Examples of this can be denying the application, requiring a cosigner on the lease, requiring a deposit that would be required for another applicant or double deposit, or raising the rent to a higher amount than another applicant. Any of these different items would be an example of adverse action. When are adverse actions permissible? Within the adverse action letter, it should contain the information of the consumer reporting agency, so that's the company that procured the consumer report, a statement that CRA did not make the decision, and a notice of the consumer's rights to dispute the accuracy found within that report. So all those items are typical items that should be within the adverse action letters. Screen One, for example, each background check comes into our system. We have pre-built letters for all of our customers to print and utilize right there on the spot. If you are, one of our letters will actually give you the ability to choose the specific reasons on why they were denied. And we actually have a conditional letter as well should you require a double deposit or any of the items that were listed above. So next we're going to talk about HUD. Most of you are probably very familiar with this. As I said earlier, on April 4th, 2016, HUD released a guidance for all housing providers regarding the use of criminal background checks and how they could potentially violate fair housing laws. In the guidance, one of the biggest focuses they had was the disparate impact discrimination. Real quick, definition of disparate impact. Disparate impact in United States labor law refers to practices in employment, housing, and other areas that adversely affect one group of people of a protected characteristic more than another. Even though rules applied by employers or landlords are formally neutral. Although protected classes vary by statute, most federal civil rights laws protect based on race, color, religion, national origin, and sex as protected traits. And some laws include disability status and other traits. Excuse me. So basically, the HUD guidance, it states that landlords and property managers cannot have a blanket policy regarding criminal records. You can't simply say, if you have a felony, I'm not going to rent to you. You must consider mitigating factors. So disparate impact, the HUD guidance states that due to the higher than average incarceration rates among certain races, that use of criminal history to deny housing can disparate impact on those races. If property managers and landlords want to use criminal background checks as part of their rental criteria, then they must show that it is necessary to use criminal background checks in order to achieve a non-discriminatory business objective, and there is no less discriminatory alternative. All right, so going further into the HUD guidance, the HUD memo continues to say that in order to meet this burden when a landlord's policy has disparate impact, landlords must consider the following: arrest records. HUD recommends that landlords should not use arrest records on a basis for excluding applicants. HUD states that an arrest which does not lead to a conviction does not prove that the individual engaged in illegal activity. Therefore, arrest records do not indicate a threat to the safety of residents of the property. HUD also goes on to discuss prior convictions. HUD states that a housing provider that imposes a blanket prohibition on any person with any conviction record, no matter when the conviction occurred, what the underlying conduct entailed, or what the convicted person has done since then, will be unable to meet this burden. Therefore, if a landlord is going to use criminal records as part of the criteria, the policy must be narrowly tailored. The HUD guidance goes on to state that even then, the landlord will still need to prove that this policy is necessary to serve a substantial, legitimate, non-discriminatory interest. To meet this requirement, the landlord must be able to show that its use of criminal background checks accurately distinguishes between criminal conduct that indicates a demonstrable risk to resident safety and or property and criminal conduct that does not. Unfortunately, the HUD memo does not specify the types of criminal convictions that would warrant a denial to rent. However, the HUD guidance does provide general guidelines that landlords must consider when denying a potential resident. They must consider the nature of the conviction. The HUD guidance states that landlords must take into account the nature and severity of the consumer's conviction record. They must also consider when the criminal activity occurred. The HUD guidance also states that landlords must take into account how long ago the criminal activity occurred. According to HUD, there is criminological research which shows that over time, the likelihood that a person with a prior record will engage in additional criminal conduct decreases until it approximates the likelihood that a person with no criminal history will commit an offense. In short, HUD is stating that criminal records that occurred a long time ago should be considered less relevant. And the other item here, individualized assessment. The HUD guidance also states that landlords must also conduct an individualized assessment of each applicant that has a criminal record. Landlords should consider several factors before making that final decision. For example, A, the facts surrounding the criminal conduct, B, the age of the individual at the time of the conduct, C, evidence that the potential tenant has maintained good rental history before and after the criminal offense, and D, evidence that the individual has taken rehabilitation efforts. The one thing that you'll notice here, each one of you are more than likely also an employer. And I believe it was 2012, roughly it was 5 to 7 years ago. The EEOC, which is the Equal Employment Opportunity Coalition or Commission, the EEOC basically came out with a guideline that states that is very similar to this HUD guidance. The EEOC guidance that came out basically said, as an employer, you cannot have a blanket policy. You must take into consideration the age of the offense, the nature of the offense, how the offense relates to the job, and conduct an individualized assessment. All of this closely mirrors to the HUD guidance from last year. This is a sheer indication that compliance with HUD, the FCRA, and state laws is becoming a more important aspect in the tenant screening space. For years, screening tenants was lenient and not heavily enforced. However, due to the recent uptick in class action lawsuits and litigation, it is becoming more and more important that your background screener is compliant, not only with the FCRA, but these different state laws. Okay. Sorry, I went back a few. So it's easy to get lost in the maze of the different laws, regulation, and guidance. It's important for you when choosing a background screen provider that the provider you are choosing is aware of the current climate in this industry and can help protect you and mitigate potential risks that come with screening candidates. Screen One has implemented a lot of policies and procedures behind the scenes to help mitigate these risks, not only for us as a consumer reporting agency, but also for our customers. So how do we do that? A lot of the stuff, as I said, happens behind the scenes, but there's a few items that we have built within our system to help our customers remain compliant. One of the items that we have come up with are criminal record buckets. Basically, this gives our customers a chance to choose from 4 different buckets on how we screen your candidates. In the HUD guidance, it talks about age of the offense. We have to take that into consideration. So some of these have 7-year restrictions where we're only going to look for criminal records within a 7-year range. So the 4 different buckets we have come up with is felony conviction within the past 7 years. So basically, we give our customer a choice of, do you only want us to look for felony convictions within the 7 years? When I say look, a lot of this relates to having to verify a national criminal database record at the county level. We talked about the FCRA compliance in doing so, which is section 607 of the FCRA. So as a background screen provider, we have to get away from solely relying on these databases, the national criminal, to report criminal records to our customers. If we find a possible record, we're going to dig down at the county level. So when we dig down at the county level, it costs more time, reality of the fact. So by choosing one of these different buckets, we determine, okay, if we find a misdemeanor DUI and you choose bucket 1 for how you want us to handle your screening, then a misdemeanor DUI does not fall within the bucket number 1, which is felony convictions within the past 7 years. So by not having to go to the county, we can speed up that investigation and only give you the information that you're looking for. Bucket 2 would be felony and misdemeanor convictions within the past 7 years. So if we find within the National Criminal Database a felony or a misdemeanor conviction within the 7 years, and that's how you want us to screen your reports, we will then go to the county level and find those records and verify their accuracy. Bucket 3, all available records except minor traffic offenses within the past 7 years. And bucket 4, all available records except minor traffic offenses as far back as available and allowed by law. So we talked about California. They won't let us report any records beyond 7 years. So in California, we wouldn't go back more than 7 years. But in Florida, Florida's a very lenient state. If we find a record from 30 years ago, we can report it as long as it's a conviction. So bucket 4, when it says all minor traffic offenses as far back as available and allowed by law, if we find a record from 30 years ago in Florida that is a conviction, we will validate that and verify its accuracy at the county level and report that to you. The purpose of these buckets, as I say, is it's designed to help you comply not only with the HUD guidance, but also speed up the background screening process. It also helps keep costs down through efficiency and accuracy by only digging further at the county level for those records you have most interest in. So how can it help save you time, money, and avoid lawsuits? With over 3,200 jurisdictions to investigate, we help streamline that process. We make sure that our background searches are accurate, thorough, and verified at the source. We verify all national criminals at the county level, which helps keep you in compliance. Unverified criminal records at the national level can result in inaccurate records in litigation. The bottom line, while turnaround time of the screening process is a priority in the long run, it's the accuracy of the information that's paramount to all concerned. We've got your back to help with the accuracy, thorough, and timeliness of the investigations. Screen One also offers our customers scorecards. The purpose of Tenant scorecards is simply to streamline that process of reviewing a background check. We have a way of automating and setting up your criteria. It's all pass and fail criteria, and we can consider several different items such as credit score. Do you have a certain credit score you accept, deny, or maybe it's conditional and requires a double deposit? We can easily automate the income to rent ratios, determine how many delinquent accounts, charge-offs, bankruptcies, and different trade lines like educational, medical, etc. And we can automate this process. So when you order a credit report within our system, this scorecard will automate the entire criteria that you need for your property. And instead of spending the time and effort of going through a credit report, looking at each individual trade line, you have an automated process of pass-fail criteria that can streamline your review of those criminal background checks. So as a synopsis, the background screening industry and the use of background checks is an ever-changing, compliant, challenging landscape. In today's day and age, the stakes are way too high to select the background screening company to assist you in choosing the highest quality tenant and avoid the litigation process. Screen One, we help you with our easy-to-use online process. It's fast, reliable, and all of our results are compliant. This concludes my webinar for today in regards to the FCRA, HUD, and background screening current landscape. At this point in time, we can open it up to any questions, Q&A that you may have out there.
Go ahead, please, if you have some questions, and put the questions in the Q&A session, and we'll read them out loud and give Troy a chance to answer. And as necessary, we'll also help answer the questions via email and telephone outside of this call. So go ahead and get your questions. Garland, I know we had one to start.
Yeah, absolutely.
Let me go ahead and introduce you. Sorry about that, Garland. Let me introduce you, everybody, to Garland Farrell. Garland is actually, he is with Property Boss Solutions, and he is a national account manager with us, and he focuses on the screening and the payment processing products very specifically. So Garland, if you want to handle those questions, that'd be great.
Sure. I think we only have one as of now, but as a brief introduction, because I don't think we did at the beginning, Screening One is our new tightly integrated partner with Property Boss. So if you have the application portal or prospects within Property Boss, you will be able to run the screen directly out of Property Boss. This partnership began about 2 or 3 months ago, and we have several clients already using the product. If you have any other questions on that, feel free to contact me at a later date, or if you'd like pricing or things of that nature, I'm happy to help you with that. The one question that we have right now, Troy, for you is, where can we obtain or make sure our forms are UTD?
All right, so when it comes to your forms, the biggest, to make sure that they're up to date and compliant, if you're with your current provider, I would lean on them. It's up to, they have inside and outside counsel that can advise with the ever-changing laws in regards to the wording that should or should not be in there. It's important to lean on them. For example, here at Screen One, we've retained outside counsel who is a preeminent FCRA attorney. She's actually advised Congress and Capitol Hill on FCRA, so she's one of the best in the industry, and we have her write up all of our disclosure and authorization forms, which we distribute to our customers. So I think the best bet's leaning on your current provider, and also making sure that with that current provider, they do have some sort of counsel who is constructing those documents, because that's very, very important. But here at Screen One, we have an outside counsel that builds those documents, and we distribute those out to our customers.
Perfect. Thanks, Troy. I will head on to the next question, the cost for the services. Right now, we have 2 packages, a basic and a premium. The basic is a credit and eviction check. And the premium is credit, criminal, and eviction. But if you need something other than that, like employment or prior residence, we can kind of customize the package for you, which is one of the nice features with this product. Is there's drop-down menus within Property Boss where we can customize a package of products that you prefer and have that in there for you. Another question, let's see. I guess another question that just came in involved the cost, which I just covered. Does anyone else have any specific questions for Troy or I?
I saw one in there for a recommended credit score. So when it comes to credit score, it's hard to recommend one, simply being you have to look at your properties, whether you're student-facing property, or you have to look at your property and your demographic, for example. We've had some companies who accept anything between over a 500 but deny anyone below a 500, which is relatively low. So then we have some properties who only accept over 700. So you really have to look at the clientele and the demographic within your area, the type of people your property is really bringing in. I think it's important to take a snapshot of, maybe the last 10, 20 people have come in your door, or maybe even look at current residents and take a look at some of their background checks and see where your success has been, and really utilizing that to come up with what's a good median, okay? Well, I've had a lot of success with people over a 650 credit score. So maybe you would want to add, with the scorecard criteria we showed, anyone over 650 would be an automatic pass. Anyone below 650 would be a fail. So I think it's important to really look back at some of your prior screenings and seeing where your success has been to come up with a good, happy medium on what would suit your property the best.
Perfect. Thanks, Troy. I think I left out the cost of the premium screen. So the basic, the credit and eviction is $10, and the credit, criminal, and eviction, the premium product, is $15. I apologize for not mentioning that earlier.
Wonderful.
Any other questions? If so, go ahead and pop them in the Q&A section. We'll give it just a moment more. Shannon wants to know, will there be any charges when running our credit reports in Property Vault?
Any changes? Yeah, there will be no changes. The integration is set up very similarly to our previous partners, so it's very easy. You just basically choose screening one under applicant screening and set up preferences, and the whole process should remain the same. Should be very easy.
I see another question here.
Yeah, there's another question in regards to signing up or a free trial period. I can send you the application. So anybody that would like to see the Screening One applications, just shoot me an email. G as in golf, Farrell at propertyboss.com. So that's GFERRELL at propertyboss.com. And I'm happy to send those Screening One applications out for you to view.
I wanted to go ahead and mention to everyone at this moment that we are actually offering a class that in some ways ties into our subject matter today. We're offering a web class on Friday at 3 p.m. and that's Eastern Time. It's called Managing Prospects from Lead to Lead. And that will be offered by Shelley, and I'll be the moderator. You will get an email inside of the next 24 hours. The cost will be $50, and you can decide if that's something you'd like to tune into. So once again, it's a class called Managing Prospects from Lead to Lead, and that will be Friday afternoon, this Friday, at 3 p.m. That's Eastern Time, and the cost will be $50. Any more questions? Well, I'd certainly like to thank our guest speakers today. Troy, that's so informative and very, very helpful, I'm sure, for all of our clients. Additionally, Garland, thank you for being there to help out answering those questions and making yourself available to all of our clients and more to learn more about Screening One. And that concludes our presentation today. Thank you, everyone, and enjoy your day.